for whom is this court accessible for?
Is exclusive for this. That means to say your vehicle can go in that. It could be a highway,
Yes.
flyover, where it can reach faster.
Yes.
So commercial dispute resolution process is something similar to that.
So you've time and again told us during today's conversation that Commercial Court Act focuses on ease of doing business. Now this ease of doing business is a very important aspect, I would say, because more so when the government is giving impetus for startups.
The litigation is must, then only go to the commercial court. I would put it in one word. It is something like a patient getting admitted to a hospital. First he has to go to the outpatient. If it's a serious dispute, requires any consideration, then only is admitted to the hospital.
So when you mention that all these disputants can come before the commercial court, is there any restriction or prohibition or any sort of qualification as to who can approach the court? So you mentioned about specified value and you mentioned the types of disputes which can come. Is there a bar on restriction on which person can come? So is it necessary that only companies can come before the court? Can individuals come? Can a layman come? So for whom is this court accessible for?
It's a good question. See, it has defined the word commercial dispute. It is not saying commercial transaction.
Yes.
That is to say, what is recognized as a commercial dispute could be even applicable to a flower vendor.
Yes.
It could be applicable to a contractor.
Yes.
It could be a small contractor. It could be a huge contractor, a big contractor having huge stakes.
Yes.
So 3 lakh and above any dispute. It could be in the corner of India, maybe in the corner of Jammu and Kashmir, or it could be in Madhya Pradesh or Kerala. All will have the same application where all of them will be a commercial disputant. 3 lakh and above should be the specified value, that is to say the difference in the amount. So they are the people. So it could be a professional like you and me.
Yes.
It could be a chartered accountant whose fees is not paid. An architect designs a house and he charges.
Yes.
It is a service. So that fees is not paid. He also is a commercial disputant.
Yes.
So to put it in broad, all are commercial disputants
Yes.
in the event there is a dispute.
Yes.
So it is not general, limiting it to high stake matters.
Yes.
It is also taking into account even a small trader. It could be I would say, milk vendor who has supplied probably in excess of 3 lakh rupees and there is a dispute, to even a big contract involving the multinationals.
Yes.
All of them will be the commercial disputants.
Yes.
The idea is faster progress.
Yes.
The man who has invested money should get justice quickly. It should not be that his money is blocked and he is not able to do his business. So ease of doing business, that's a word which you have to keep in mind.
So you've time and again told us during today's conversation that Commercial Court Act focuses on ease of doing business. Now this ease of doing business is a very important aspect, I would say, because more so when the government is giving impetus for startups.
Exactly.
A lot of incentives,
Yes.
tax benefits and other benefits for industrialists or anybody who wants to start up
Yes.
with the Make in India project sort of. These similar incentives. So when you're saying ease of doing business, can you just tell us how, by comparing with civil courts, as to how the procedure in Commercial Court Act is much faster and quicker in comparison to earlier civil trials before the civil court?
Veena, I can give you this example. You are driving from, say, Bombay to Punjab.
Yes.
You are going in a road. What would be the time required? We'll assume it is 5 hours in the
Yes.
journey. I'm just talking
Yes.
some destination.
Yes.
What if there is a separate track named as road from Bombay to, say, Chandigarh or some part of Chandigarh? Exclusive road made only between Bombay to Chandigarh. The track is exclusive for this. That means to say your vehicle can go in that. It could be a highway,
Yes.
flyover, where it can reach faster.
Yes.
So commercial dispute resolution process is something similar to that.
Yes.
It is focused, the law is simpler, the usual delays which we see in the courts, like the adjournments, the lengthy cross-examinations,
Yes.
producing voluminous documents and that coming in the way of the disposal, because you have to apply your mind.
Yes.
All that is taken care in this Commercial Courts Act,
Yes.
where it is simplified. As I put it to you, I can give another example. You had seen probably this 5-day cricket test matches.
Yes. Yes.
At the end of the 5th day, probably they were not having any result.
Yes.
Even one team could not have probably ended the innings.
Yes.
As against that, we have this now 2020 cricket match, where the result is a must. So we can compare the regular civil dispute resolution process as 5-day test match, and this as a 2020 match, where both will be looking at a result rather than just playing the game of cricket.
That's a very good example, sir. I think that just puts forward how, the comparison between a trial before a civil court and a commercial court. Sir, can you tell us, as a layman, as somebody who has no background in law, if he or she were to decide to go before a commercial court, what should one be prepared with to take the first call?
The first thing is 3 lakh rupees.
Okay.
Anything above 3 lakh rupees, then it's a commercial dispute. Second thing is the biggest advantage or the game changer, I would say, in this concept of commercial court is no one can directly rush to a court. There is a bar.
Okay.
That is to say, if A has a dispute against B, the usual scenario in a dispute, civil dispute, he lodges a case. Maybe he will
Yes.
exchange some notice,
Yes.
or it could be a statutory notice as
Yes.
required under law. Then he lodges a case. That is to say, he lodges a dispute. The litigation is lodged. Here there is a bar. Everyone has to first exhaust or explore the process of mediation. It is called as a pre-institution mediation.
Is this a statutory bar, sir?
Yes, it's a statutory bar. Everyone who has a case cannot directly approach a commercial court. He has to first lodge a pre-institution mediation by approaching the district legal services authority of the jurisdiction. That is to say, the concept is first mediate. If you are not able to get result, then only go to litigation. The earlier concept was, that is to say, I am talking of 1908 Act, which was first litigate. Then we saw the change in the concept where they said, you litigate, but also try to find alternative dispute resolution mechanisms, try to find solutions through the ADR process, we call it, Section 89.
Yes.
Which means mediation was also one among that. It is one of the post-litigation process. Now, the law, the game changer I would say, recognizes twin mechanism. First, mediate. If you get a good result, satisfactory result, you are avoided of a litigation. You are not happy, the litigation is must, then only go to the commercial court. I would put it in one word. It is something like a patient getting admitted to a hospital. First he has to go to the outpatient. If he says it's a serious dispute, requires any consideration, then only he is admitted to the hospital. So commercial court is something like a hospital, pre-institution something like the outpatient ward.
That's a
Everybody
very
gets
good
it.
example, sir. Way to understand pre-institution mediation.